A guide to duty of fair presentation. On the 12th of August 2016, the Insurance Act 2015 came into force, and with it some significant changes to legislation. One specific example of these new rules is the topic surrounding duty of fair presentation. Here's what it means for you. Under the preceding Act, your duty as the insured was to disclose all material circumstances that you knew about, anything that might affect the judgment of a prudent insurer. But going forwards, this must also include, in the normal course of business, everything you ought to know. So why has it changed? The problem was that some of the rules within the previous Act were deemed to be confusing. To clarify matters, the duty of fair presentation was introduced. In comparison to the superseded rule, this is more prescriptive and involves more guidance on what you need to disclose, whose knowledge within the organisation is relevant, and how you should present it to insurers. So, what is it? Before entering a business insurance contract, you must make a fair presentation of the risk to the insurer. You'll have to tell the insurer everything they ought to know, not necessarily your inside leg measurement, but provide enough information for them to make further inquiries. Not make any misrepresentations, no red herrings. Information must be correct and made in good faith. What you know. Considering all points in isolation, the first matter to address as the policyholder should always be, what do you actually know? You'll have to disclose every material circumstance you actually know about. This will include information held by your senior management team and those who arrange the insurance. Senior management means everyone responsible for making decisions about how you manage your activities. This includes your corporate board, but can also extend to other areas of the company. Here are a few things that you can do. Consider your corporate structure. Map out a chart of all those who should have relevant information. Educate managers. They might not have been involved with this kind of disclosure process before, so let them know what's expected of them. Find out how much information you need from them and how you'll get it. Clarify with your insurers who counts as senior management in your organisation and who will be deemed as having the relevant information. Now, what about the people responsible for arranging the insurance? They are the people who work on your behalf to procure the insurance. This includes insurance and risk managers or any other function responsible for arranging insurance. It can also include people who assist the risk management team, provide advice, expert instruction, or help to collate data for the insurance submission. Here's how you can prepare now. Work out who falls into these categories. Be careful of changes to your team. If someone leaves, their knowledge could go with them. Make sure you've put measures in place to capture that knowledge before they go. Try to get an agreement from your insurance company to limit and specify who falls within this category. Make sure you have a clear agreement about who does and who does not. Identify any people at your brokers or any intermediary you use who help to arrange the insurance. What you ought to know. Under the Act, you'll have to disclose everything you ought to know, which is where problems can arise. This includes everything you can find out with a reasonable search for information, including information held within the organisation and by anyone else such as an agent, consultant or intermediary. Disclosing material. You must disclose all this information in a way which is reasonably clear and accessible to your insurer. If you don't, it could breach the terms of fair presentation. Even if you've provided all the information required, your insurers may have a way out if it's hard to find. This rule is to stop people from dumping huge amounts of data on their insurance company, so whilst the information might be there, it's pretty difficult to find it. Now the onus is on you to ensure information is clearly presented and signposted. Last but not least, remember your duty is to ensure that you do not misrepresent. This rule already exists and means every representation you make has to be factually correct and it has to be made in good faith. These rules are intended to make things clearer for businesses. Try to maintain clear communication between yourself and your insurers to make sure you've met all your requirements. Failure to comply with any of the newly implemented legislation could give insurers reason and opportunity to decline indemnity and/or adjust any settlement. In conclusion, the duty of fair presentation is but one area of a much bigger subject. For more information on this specific topic or the Insurance Act as a whole, please contact Consort. We would be delighted to hear from you and answer any questions you may have.